Judgment in the matter of Bertino against the Public Prosecutor's Office, Italy.
Lord Stevens would explain the court's judgment.
The central issue in this appeal is whether the district judge was correct to conclude that the appellant had deliberately absented himself from his trial in Italy for the purposes of Section 20, subsection 3 of the Extradition Act 2003, so should be extradited to Italy to serve his sentence. A European Arrest Warrant, the warrant, sought the surrender of the appellant to Italy to serve a sentence of 1 year's imprisonment imposed following a trial in Italy in his absence. The offence was one of sexual activity with an underage person. It was alleged to have been committed on the 19th of June 2015 in the province of Venice at a holiday camp at which the appellant was working. The police were informed and attended the appellant's place of work. His phone was seized. He was not arrested or questioned formally, though he went to the local police station. The appellant was sacked from his job and returned to Sicily, from where he came. He later voluntarily attended a police station in Sicily on the 23rd of July 2015. He signed a document which recorded that he was under investigation. The document invited the appellant to elect domicile in Italy. The document stated that, as the appellant is being investigated, he is under an obligation to notify any change of his declared or elected domicile by a statement to be rendered to the judicial authority. It also warned that if the appellant does not notify any change of his declared or elected domicile, the service of any document will be executed by delivery to the defense lawyer of choice or to a court-appointed defense lawyer. The appellant elected his domicile by giving an address in Messina. He also indicated on the form that he will be assisted by a defense lawyer that will be appointed by the court. The document was read to him, and both he and the police officer signed the document of which the appellant was given a copy. The appellant left Italy a few months later in November 2015 and came to the United Kingdom. The appellant notified the authorities of his departure to the United Kingdom for family law purposes, but not the police in connection with the investigation. Some 2 years after the alleged offence, and on the 8th of June 2017, the prosecution in Italy was commenced. The appellant did not receive the summons, and the trial took place in his absence. He was represented by a lawyer appointed by the court. The question of whether to extradite the appellant pursuant to the warrant was determined by the district judge by reference to the questions set out in Section 20 of the Extradition Act, read in conformity with the relevant European framework decisions which govern the executions of European arrest warrants. The only issue for determination before the district judge arose under Section 20, subsection 3, namely, whether the requested person deliberately absented himself from his trial. The district judge concluded that the appellant left the country so that he could not be served with court papers or future dates for his trial, and that he demonstrated a manifest lack of diligence in moving address without notifying the police, which was sufficient to establish deliberate absence under Section 20, subsection 3. Accordingly, the district judge ordered the appellant's extradition. The High Court dismissed the appellant's appeal, but certified a point of law of general public importance, which was, For a requested person to have deliberately absented himself from trial for the purpose of Section 20, subsection 3, must the requesting judicial authority prove that he has actual knowledge that he could be convicted and sentenced in absentia. The Supreme Court granted the appellant permission to appeal on this point and unanimously allows his appeal for the reasons set out in a joint judgment given by myself and Lord Burnett, with which the other justices agree. Which reasons I will now briefly summarize. First, Section 20, subsection 3, and the relevant framework directives reflect the provisions of Article 6 of the European Convention on Human Rights, which concerns the right to a fair trial, so that the phrase deliberately absented himself from his trial should be understood as being synonymous with the concept in the Strasbourg jurisdiction that an accused has unequivocally waived his right to be present at the trial. Second, the jurisprudence of the European Court of Human Rights, as analysed by the House of Lords in R against Jones, provides, amongst other matters, that a fair hearing requires a defendant to be notified of the proceedings against him, and that a person should, as a general principle, be entitled to be present at his trial. However, an accused can unequivocally waive his right to be present at the trial. Third, the waiver must be established in an unequivocal manner and be attended by minimum safeguards commensurate to its importance. Fourth, ordinarily for a waiver to be unequivocal and effective, knowing and intelligent, the accused must be shown to have appreciated the consequences of his behavior. That will usually require the defendant to be warned in one way or another that a failure to attend might result in a trial in his absence. Fifth, it appears from the reasoning of the district judge that he may have regarded a general manifest lack of diligence, which results in ignorance of criminal proceedings, as itself being sufficient to support a conclusion that an accused had deliberately absented himself from his trial. That is, unequivocally waived his right to attend. And in that respect, we disagree with the reasoning of the district judge. Accordingly, it was for the Italian judicial authority to prove to the criminal standard that the appellant had deliberately absented himself from trial, that is, unequivocally waived his right to attend. The appellant was never officially informed that he was being prosecuted, nor was he notified of the time and place of his trial. The appellant's dealings with the police in Venice and Sicily fell a long way short of being provided by the authorities with an official accusation. He knew that he was suspected of a crime and that it was being investigated. There was no certainty that a prosecution would follow. When the appellant left Italy without giving the judicial police a new address, there were no criminal proceedings of which he could have been aware. Still less was there a trial from which he was in a position to deliberately absent himself. Accordingly, the Italian judicial authority has failed to prove to the criminal standard that the appellant had unequivocally, in a knowing and intelligent way, waived his right to attend his trial. The district judge should not have ordered his extradition. In relation to the certified question, the court declines to categorically answer that the requesting authority is always required to prove that the requested person had actual knowledge that he could be convicted and sentenced in absentia. The European Court of Human Rights has been careful not to present the issue in such stark terms. Behavior of an extreme enough form might support a finding of unequivocal waiver, even if an accused cannot be shown to have had actual knowledge that the trial would proceed in his absence. However, that is not this case. In this case, the Italian requesting authority has failed to prove that the appellant had unequivocally, in a knowing and intelligent way, waived his right to attend his trial. Accordingly, the appeal is allowed, the district judge's extradition order is quashed, and an order is made discharging the appellant.